Whenever you're ready, Madam Chair.
Thank you. All right. Good morning. I'm going to go ahead and call the meeting of the Commission on State Mandates to order at 10:03. Welcome to our hybrid meeting. For those participating in person, I have some housekeeping information. On the table at the back of the room are paper copies of the meeting's revised notice, agenda, new filings, and witness lists. The electronic public hearing binder is also located there on a laptop. Please note that the room is microphoned, so speakers and microphones on all devices must stay muted for the duration of the meeting to eliminate feedback noise. When called up for an item, the parties and the witnesses will please come to the table and sit at the designated laptop. The restrooms are located out the entrance door and through the door on the left. The men's restroom is located on the right, and the women's restroom is at the end of the hallway to the right. Finally, please take note of the emergency exits in the room. In the event of an emergency, please exit the door to my left, turn left, and go down the stairs. For those participating remotely, the materials for today's meeting, including the revised notice, agenda, new filings, and witness lists, are all available on the Commission's website, www.csm.ca.gov, under the Hearings tab. When being sworn in at the beginning of the hearing and when called for an item, the parties and witnesses will please turn on their video and unmute their microphone. At the conclusion of the item, please turn off the video and mute the microphone. In the event we experience technical difficulties or the meeting is bumped offline, we will restart and allow time for people to rejoin before recommencing the meeting. If we are unable to restart, a notice will be posted on the Commission's website listing the items to be heard at the next meeting. Please remember to speak slowly and accurately for the benefit of the court reporter and an accurate transcript of the hearing. Finally, before we begin, it is my pleasure to introduce Monica Jimenez, counsel for the State Treasurer's Office. Juliana, will you please call the roll?
Mr. Adams.
Here.
Ms. Gallegos.
Here.
Ms. Green Ross. Ms. Jimenez.
Here.
Ms. Nash.
Here.
Ms. Peralt.
Here.
Mr. Powell.
Here.
Madam Chair, we have a quorum.
Thank you so much. All right. Our next item is item 1, election of officers and personnel legislation and litigation subcommittee appointments. Oh,
Thank you.
I said your line.
That's fine. Thank you, Madam Chair.
Okay, let's move right into nominations, shall we? I was going to be smooth about this. Are there nominations for chairperson, and is there a motion for election of the new chairperson? Okay, there's been a nomination by Mr. Adams for Director Stephen Shaw, Department of Finance, to remain as chair. Are there any other alternate nominations? Okay, seeing none then, is there a motion for, oh, do I need to go? Oh, yeah, well, but don't I need a motion first? He did a nomination. Throw me off.
A nomination goes directly to vote.
I didn't know that. I thought we had to do 2. I thought we did 2 last year, two things. Okay, just covering our bases. We have a nomination, which is also a motion. Do we have a second? Okay, second by Ms. Green Ross. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross. Ms. Jimenez.
Aye.
Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Okay, that motion carries. Okay, let's move now on to vice chairperson. Are there nominations for vice chairperson? And is there a motion for election of the new vice chairperson?
Madam Chair, I'd make a motion to nominate Fiona Ma, the State Treasurer, as Vice Chair.
Okay, we have a motion by Mr. Adams for Treasurer Fiona Ma to be the vice chairperson. Are there any other alternate nominations? Okay, seeing none, then that will act as the motion. Is there a second?
I'd be happy
Second
to.
Oh, okay. Well, second by Ms. Gallegos. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross. Ms. Jimenez.
Aye.
Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
All right, that motion carries, and we would
That
do
brings
that a
us to
little
the
faster.
subcommittee appointments, Madam Chair.
Okay.
Last year, the subcommittee members as elected were for the Personnel Subcommittee, Joe Steppenshaw, Director of the Department of Finance, and Fiona Ma, State Treasurer. For the Legislation Subcommittee, Malia Cohen, State Controller, and Lee Adams, County Supervisor, Samuel Asefa, Office of Land Use and Climate Innovation, Alternate. And for the Litigation Subcommittee, Fiona Ma, State Treasurer, Renee Nash, School District Board Member, and Malia Cohen, State Controller, Alternate.
Thank you. We may need a reminder as we move through, but.
My
appreci-
pleasure.
Appreciate that. All right, so let's go ahead and take up the Personnel Subcommittee appointment first. So are there nominations to the Personnel Subcommittee? And is there a motion for appointment of the Personnel Subcommittee members? Remind me, that is, currently it is Director of Finance and
State
State
Treasurer.
Treasurer. Okay. I'll go ahead and nominate both of those individuals to remain on the Personnel Subcommittee. Are there any alternate nominations? Seeing none, we'll take that as a motion. Is there a second?
I would second.
Okay, seconded by Mr. Adams. If we could please have a vote.
Mr. Adams,
Aye.
Ms. Gallegos,
Aye.
Ms. Green Ross, Ms. Jimenez,
Aye.
Ms. Nash,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Aye.
Okay, that motion carries. Let's go ahead now and take up, oh, sorry.
It is the Legislation Subcommittee next. Those members, just as a reminder, are the State Controller and Lee Adams, County Supervisor, Office of Land Use and Climate Innovation as the alternate.
As the alternate, okay. Okay. Are there any nominations to the Legislation Subcommittee? Is there a motion for appointment of the Legislation Subcommittee members?
I'll move that the committee remain the same as it is.
Okay, is there any alternate nominations to that? Seeing none, we'll take that up as a motion. Is there any questions? Okay, is there a second? Second by Ms. Green Ross. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos,
Aye.
Ms. Green Ross, Ms. Jimenez,
Aye.
Ms. Nash,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Aye.
Okay, that motion carries.
And finally, the Litigation Subcommittee. Currently, it is the State Treasurer, Ms. Nash, School District Board Member, and the State Controller Alternate.
Okay, thank you so much. Are there any nominations to the Litigation Subcommittee, and is there a motion for the appointment of the Litigation Subcommittee members? Okay. Is there any alternate nominations or objections?
Madam
Okay.
Chair, I
Yes, Dennis.
hate to interrupt, but I noticed that Member Ross's microphone may not be on the desk,
Oh.
and we can't hear her properly.
Thank you. Would you go ahead and just repeat that motion then, please?
Yes, I move to reelect the ongoing committee, subcommittee members.
Okay. Is that better? Can everybody hear now? Yes. Okay, great. Okay, so we have a motion to continue with the current committee members. Seeing no alternate nominations and no objections, is there any comments? Okay, is there a second to that motion?
Second.
Okay, we have a second. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez.
Aye.
Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
All right, that motion carries. Thank you so much. We are now moving, I believe, on to item 2. So are there any objections or additional, this is the minutes. Are there any objections to or additional corrections to the December 5th, 2025 minutes? Okay, seeing none. Are there any public comments on this item?
Madam Chair, there are no online public comments.
And we have none here in the room. Is there any further discussion? Okay, seeing none, is there a motion to approve the minutes?
I will so move to approve the minutes.
Okay, it has been moved. Is there a second? Second, excuse me. I'll go ahead and second. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez.
Aye.
Ms. Nash.
Abstain.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Okay, that motion carries. And we will now go ahead and take up public comments for those matters not on the agenda. Is there anybody that would like to speak and provide public comment on items not agendized today? I see none in the room. Is there any online?
Madam Chair, there are no public comments online.
Okay. Okay. Hearing none, we'll go ahead now and move on to our next item. Julia.
The swearing in. There are no items proposed for consent at this meeting, so we're moving directly to swearing in. Will the parties and witnesses for items 3, 4, 5, 6, and 7 participating remotely, please be sure that both your first and last names are listed on your Zoom window for the benefit of the court reporter. Turn on your video and unmute your microphone. The parties and witnesses participating in person for item 4, please approach the witness table, and all parties and witnesses, please rise. Beginning with item 3. On behalf of the claimant, the County of Los Angeles, participating remotely, please state your names for the record.
Hi, my name is Fernando Lemus. I am the claimant representative for the County of Los Angeles.
Hi, my name is Tiffany Walston, Deputy County Counsel. I am the claimant.
And now, for the Department of Finance, participating remotely, please state your names for the record.
Chris Hill, Department of Finance.
Haley Yap, Department of Finance.
Thank you. Item 4, on behalf of the claimant, the County of Santa Clara, participating in person, please state your name for the record.
Good morning. My name is Rajiv Narayan, Deputy County Counsel for the County of Santa Clara, and I will be the claimant representative.
And now, for the Department of Finance, participating remotely, please state your names for the record.
Chris Hill, Department of Finance.
Haley Yap, Department of Finance.
Item 5, on behalf of the claimants participating remotely, please state your names for the record.
Howard Guest, on behalf of the claimants.
And now for the Department of Finance, participating remotely, please state your names for the record.
Chris Hill, Department of Finance.
Haley Yap, Department of Finance.
Item 6, on behalf of the claimant, County of Los Angeles, participating remotely, please state your names for the record.
My name is Fernando Lemus. I am the claimant representative for the County of Los Angeles.
Tiffany Walston, Deputy County Counsel for the County of Los Angeles. I am the claimant representative.
And now for the Department of Finance, participating remotely, please state your names for the record.
Chris Hill, Department of Finance.
Haley Yap, Department of Finance.
Item 7, on behalf of the claimant, County of Santa Clara, participating remotely, please state your names for the record.
Good morning. I'm Joshua Walden, Deputy County Counsel of County of Santa Clara. I'm representing the claimant for item 7.
And now the Department of Finance, participating remotely, please state your name for the record.
Chris Hill, Department of Finance.
Haley Yap, Department of Finance.
Thank you. Do you solemnly swear or affirm that the testimony which you are about to give is true and correct, based on your personal knowledge, information, or belief?
I do.
I do.
Yes.
Yeah.
Thank you. We now ask the presenters participating remotely for items 4, 5, 6, and 7 to please turn off their video and mute their microphones. And those presenting in person, please return to your seat. Next is item 3. Senior Commission Counsel Laura Daugherty will please present a proposed decision on stops, notification by peace officers, 24 TC 03.
Good morning. Item 3 is a test claim alleging new state-mandated activities and costs resulting from Vehicle Code Section 2806.5 as amended in 2022. This code section makes new requirements of peace officers who make a traffic or pedestrian stop and intend to question a detained driver, passenger, or pedestrian. Before engaging in questioning about a criminal investigation or traffic violation, the officer must state the reason for the stop. The officer must also document the reason for the stop on any resulting citation or police report. Exception exists when the officer reasonably believes that withholding the reason for the stop is necessary to protect life or property from imminent threat, such as in cases of terrorism and kidnapping. Prior law required documenting the reason for the stop under code sections concerning DUIs, which are specified in the proposed decision, but the test claim statute's requirements are otherwise newly required. Commission staff finds the test claim statute imposes a reimbursable state-mandated program within the meaning of Article 13B, Section 6 of the California Constitution and Government Code Section 17514, and recommends the Commission approve this test claim beginning July 1st, 2023, and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you. If the parties and witnesses would please state your name for the record on this item.
Sure. My name is Fernando Lemus, and I'm the claimant representative for the County of Los Angeles. And I'm here to say that the County of Los Angeles agrees with the Commission's decision.
Okay, hold on 1 second,
sorry.
Mr. Lemos.
Didn't mean to
No,
get
that's
ahead of you.
okay.
I apologize.
I appreciate your efficiency. Do I have a Ms. Walston also online?
Yes, Tiffany Walston, Deputy County Counsel for the County of Los Angeles, and I am the claimant representative.
Thank you so much. All right, now I will go back to whoever would like to start. Mr. Lemos, if you have comments, or Ms. Walston, go right ahead.
Sure. I was just stating that the County of Los Angeles, we agree with the Commission's decision, and thank you.
Thank you. Ms.
Thank
Walston?
you. Thank
Okay.
you. Yes, I also agree with the Commission's decision, finding that the test claim legislation is a new requirement and does mandate additional costs for this county.
Thank you so much. Okay, let me go ahead and turn Mr. Hill or Ms. Yap from the Department of Finance. Do you have any additional comments?
Haley Yap, Department of Finance. Finance has no comments on this matter. Thank you.
Okay, thank you so much. This again is item number 3. Is there any public comment on this item? Seeing none in the room, is there any online?
Madam Chair, there are no public comments online.
All right, let me bring it back to the commission. Are there any comments from commissioners or questions? Okay, seeing none, is there a motion?
I will move to adopt the proposed decision.
Okay, moved by Mr. Powell. Is there a second?
Second?
Seconded by Mr. Adams. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez.
Aye.
Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
All right, thank you. That motion carries.
We now ask the presenters participating remotely for item 3 to please turn off their video, mute their microphones. Next is item 4. We now ask the presenters participating remotely for item 4 to please turn on their video and unmute their microphones, and those presenting in person, please come to the table. Senior Commission Counsel Laura Doherty will please present a revised proposed decision on child physical abuse and neglect exams 24 TC 05.
Good morning again. Item 4 is a test claim alleging new state mandated activities and costs resulting from Penal Code Section 11171F as amended in 2023. As of January 1st, 2024, this code section prohibits counties from billing a child or the child's insurance for a child physical abuse or neglect medical exam. An adjacent code section, Penal Code Section 11171G, created a system of state funding under which county medical examiners are to submit invoices to the California Office of Emergency Services. However, no appropriation has been made. Prior to January 1st, 2024, the counties billed the child's private insurance if available and Medi-Cal or the State Victim Compensation Board. Commission staff recommends a partial approval of this test claim, finding that Penal Code Section 11171F, as amended by the test claim statute, imposes a reimbursable state-mandated program beginning January 1st, 2024, on counties within the meaning of Article 13B, Section 6C of the California Constitution, only for the costs incurred for child physical abuse and neglect exams when the child is eligible for Medi-Cal or Victim Compensation Board coverage. These costs were previously borne by the state and have been shifted to the counties under Article 13B, Section 6C. Reimbursement is not required to the extent the legislature appropriates funds for child physical abuse and neglect exams under Penal Code Section 11171G. All other costs alleged are recommended for denial. Staff recommends the Commission partially approve this test claim and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you so much. If the parties and witnesses for item 4 would please state your name for the record.
Good morning. My name is Rajiv Narayan. I'm here representing the County of Santa Clara claimant in this action.
Thank you so much. I apologize. I was looking on the screen and didn't realize you were right in front of me. Okay, Mr. Narayan, for the claimant, would you like to begin?
Yes, I'd like to. So I have some prepared remarks today, but before that, I think it's important to express a deep amount of gratitude to the Commission staff and the Commission for both putting together a very comprehensive proposed decision and revised proposed decision that engages with the issues. We submitted a number of comments, and we're really grateful to the Commission staff for meeting us at every stage to explain their reasoning. Of course, we have some disagreements that we'll go through today, but I also want to express gratitude to the Commission for wading through the many hundreds of pages and comments and analyses that comprise the test claim decision. So what I would like to do is provide a little bit of background for the Commission about what the law does that will be helpful to understanding the scope of my comments, and then I'll discuss what we believe to be the key dispute between the claimant, County of Santa Clara, and the Commission staff as to the revised proposed decision. So with that, let me first talk a little bit about AB 1402. Counties provide child abuse exams to all child victims who need them. That's a really important function that we play. It's one that we take extremely seriously. To that end, we agree with the proposed decision where it states that fundamentally the rights of children come first. The duty that counties have across the state to investigate and potentially prosecute or exercise child welfare functions when there is a suspicion of child abuse and neglect is one that we take extremely seriously. That duty, as the test claim decision points out, is mandated by a set of statutes that obligate county public safety and child welfare agencies to act on potential instances of child abuse and neglect. So under the previous law, by which I mean before AB 1402, counties were reimbursed for this important duty, providing child abuse exams, through their fee authority. We had the ability to bill Medi-Cal, we had the ability to bill the Victims' Compensation Board, and we had the ability to bill private medical insurance. That's part of what made our ability to provide these child abuse exams a sustainable activity for counties across the state. So what did AB 1402 change? What AB 1402 does, principally, is it prohibits counties from charging fees for child abuse exams. Counties must now provide those exams free of charge. We can't charge Medi-Cal, we cannot charge the Victims' Compensation Board, and we can't charge private medical insurance. There's no more fee authority. By removing the fee authority, the AB 1402 bill furthers an important state policy by making these exams more accessible to child victims, by which I mean that there's one less barrier to child victims for getting these exams. So AB 1402 didn't initially saddle counties with the bill for these exams, at least not in design. Rather, it stated that these exams would be reimbursed by the state, subject to appropriation by the legislature. Altogether, AB 1402 said that counties can't charge a fee, that the state in turn would step in and take the bill, and that it would be easier, more accessible for children to get these incredibly important exams. So what did the legislature do after AB 1402? What happened is that when AB 1402 went into effect starting on January 1st, counties stopped charging a fee pursuant to law and continued providing these child abuse exams. But then unfortunately, the legislature declined to appropriate funding to reimburse the cost of child abuse exams. So counties still provide these exams, but we absorb the cost of AB 1402 because there's no reimbursement from the state. We deem that to be an unfunded mandate under the state constitution, and accordingly, we filed the test claim that is now before the commission. So what's our dispute today? In large part, we think that the proposed decision gets most everything right. We have one gripe, which is that it recommends partial approval and it narrows approval to child abuse exams rendered to children who are covered by Medi-Cal or whose costs would otherwise have been compensated by the Victims' Compensation Board. In other words, the test claim decision says that there is no reimbursement under the law for child abuse exams rendered to children who are covered by private medical insurance. That's the part that we disagree with. We disagree with it strenuously, and it's important to us to explain why. So the claimants, of course, the County of Santa Clara and counties across the state treat every child the same. That's our ethical commitment and what the law demands. The law mandates providing these exams to all children regardless of insurance. This distinction between insurance status does not appear anywhere in the law. It doesn't appear in the duties that are imposed upon public safety operators and child welfare agencies to investigate and prosecute instances of child abuse. It doesn't appear in Penal Code Section 11171 that outlines the scope of these exams. It doesn't appear anywhere. Rather, it's the revised proposed decision that discriminates on the basis of insurance status when it comes to recommending reimbursement for one set of exams, those who would otherwise have been compensated by Medi-Cal and the Victims' Compensation Board, and not for another set of exams, those that would have been compensated by private medical insurance. So what are we asking for? What we request is for the commission to direct staff to amend the revised proposed decision to treat all child abuse exams equally, regardless of insurance status. In other words, what we are asking for is for the amended proposed decision to be a full approval rather than a partial approval. I think what would be helpful is to zero in on exactly what that legal dispute is between the county and the revised proposed decision. What the proposed decision says is that child abuse exams rendered to child victims covered by private medical insurance do not constitute a new program or higher level of service. That's a phrase I'm sure the commission has heard a lot. So let me unpack that. The revised proposed decision makes three claims to support that determination. First, it says that no new activity is required by the test claim statute as to those exams rendered to kids with private medical insurance. Two, the state has not shifted costs, which were previously its responsibility. And three, increased costs alone do not constitute a reimbursable mandate. We disagree with each of these, and it's important for us to explain why. So claim one, no new activity required by the test claim statute as to exams rendered to kids with private medical insurance. The County of Santa Clara continues to argue that the new activity in this test claim is providing these exams free of charge, plain and simple. This is the same new activity, the same new program that the proposed decision reimburses for child victims who do have Medi-Cal coverage and whose costs would have been covered by the Victims' Compensation Board. It's difficult for us to understand how one test claim statute can impose two programs, one that is new and one that is not new. So we believe that there is a new activity. It's one that covers all child abuse exams, regardless of insurance status. So claim number two, the state has not shifted costs, which were previously its responsibility. Again, the county would argue that the state has shifted costs by declining to reimburse these exams after enacting AB 1402. The proposed decision seems to argue that the fact that there was reimbursement prior to AB 1402 means that the state previously took responsibility only for one set of exams, those that were reimbursed by Medi-Cal and those that were reimbursed by the Victims' Compensation Board. We disagree with that. As the proposed decision itself states, child abuse exams are mandated regardless of child insurance status. The state didn't mandate these exams and take responsibility for only one set of them. What happened instead is that the state mandated all of these exams and provided fee authority to counties so that counties could recoup their cost under this mandate from various sources, Medi-Cal, the Victims' Compensation Board, and private medical insurance. Where the state actually assumed responsibility for these exams is with the passage of AB 1402, the test claim statute, when it declared that exams would be free and that the state would reimburse them subject to appropriation. That assumption of responsibility itself does not discriminate by child insurance status either. Claim number 3. The costs of child abuse exams rendered to kids with private medical insurance alone are only increased costs and don't constitute a reimbursable mandate. Here again, it's unclear to the county how this logic applies to exams rendered to child victims who have private medical insurance and does not apply to exams rendered to child victims who are covered by Medi-Cal or the Victims' Compensation Board. So in this case, we would ask, why is it that AB 1402 only creates increased costs for one set of exams and a fully reimbursable mandate for another set of exams? Both exam sets, regardless of insurance status, constitute the same new program. And moreover, they're not increased costs, but they all constitute a higher level of service. So to drill down even further on this point, the county disagrees with how the proposed decision purports to apply case law on this point. The proposed decision cites the City of San Jose case, which says, for the record, at page 1816, and here I'm quoting, Section 6, the state constitutional provision, was not intended to entitle local entities to reimbursement for all increased costs resulting from legislative enactments, but only those costs mandated by a new program or an increased level of service imposed upon them by the state. End quote. So far, so good. That's what the revised proposed decision quotes. However, that analysis in the City of San Jose case goes further. The very next sentence states, and I'm quoting again, Section 6 cannot be interpreted to apply to general legislation which has an incidental impact on local agency costs, end quote. For that statement, the City of San Jose case relies on 2 other cases, Lucia Mar Unified School District versus Honig in 1988, and the County of Los Angeles versus the State of California from 1987. The relevant section of Lucia Mar explains this principle by reference to the County of Los Angeles decision. So to save time, I'm just going to quote Lucia Mar at page 835. And again, I'm quoting here. In keeping with this principle, we recently held in the County of Los Angeles that legislation requiring local governments and other employers to increase certain workers' compensation benefits did not invoke the subvention requirement because the state mandate did not provide for a program. We reasoned that the additional expense to the local agency mandated by the legislation arose as an incidental impact of a law which applied generally to all state residents and entities, and this type of expense was not what the voters had in mind when they adopted Section 6 of Article 13B, end quote. So that principle, we would say, doesn't fit the facts here. As we pled in the test claim, the increased level of service is clear, providing exams that were formally billed free of charge to enhance access to child abuse exams. The fact that these exams are free is not incidental. That is the whole point of the test claim statute. The fact that these exams are free is also not general legislation. It doesn't apply to every entity in the state. It applies particularly to counties that provide these exams, that are mandated to provide these exams. The reason why the Court of Appeal in these decisions focus on incidental impacts is found in the text of the Constitution. So reimbursement is proper not just for new programs, but also for an increased level of service. What that means is that increased costs can and often do constitute reimbursable mandates as long as they come with an increased level of service. We have here an increased level of service, for providing these child abuse exams in a way that enhances access by removing the costs. That is not an increased cost alone, it is an enhanced level of service. So those are the 3 points that underlie the dispute that we have with the revised proposed decision as to its findings on child abuse exams that are rendered to kids with private medical insurance. I do want to make 2 other points briefly that the revised proposed decision adds to the record. The first is that in the revised proposed decision, there's a new argument that we saw for the first time since we filed this test claim in December 2024. The commission staff argues that its hands are tied because the county's test claim pled subdivision F of Penal Code Section 11171 rather than all of Penal Code Section 1171. as mandated by AB 1402. Just to be clear, subdivision F is that subdivision that says you can no longer charge for child abuse exams. So what the revised proposed decision basically says is that if only the county had pled the right test claim statute, the commission could have taken jurisdiction and made findings on the activities required by the 2002 statute and the cost incurred under the 2023 amendment. Because the county didn't do this, the deadline for amending the test claim has passed, and we can no longer consider all of section 11171. So we have some concerns about that finding. First, this argument, we believe, is inconsistent with the proposed decision's findings about the reimbursable mandate. The proposed decision says, and of course the county agrees, that the underlying duty to provide child abuse exams is not compelled by Penal Code Section 11171 itself, but the full panoply of public safety and child welfare laws that practically compel counties to investigate claims of child abuse. The set of laws the proposed decision references actually does include Section 11171, so it appears that the proposed decision does analyze the statute, notwithstanding its claim that the county failed to plead the entirety of Section 11171. In any case, the duty to investigate child abuse and neglect extends to all cases of child abuse and neglect. It does not discriminate on the basis of insurance status. In other words, this new claim in the revised proposed decision is one that we disagree with. The commission doesn't need to take jurisdiction of Penal Code 11171 as a whole to find a reimbursable mandate for child abuse exams rendered to kids covered by private medical insurance. I mean, by the proposed decision's logic, taking jurisdiction of Section 11171 would not actually change the analysis here. We have another more procedural concern about this argument. The revised proposed decision seems to suggest that the county should have pled the full statute when we only pled a subdivision. We're a little disappointed by that finding in the administrative record because the county did in fact plead all of Penal Code Section 11171 when we first filed the test claim in December 2024. We thought this was the best way to capture the full effect of the statute as it was amended by AB 1402. On January 17th, 2025, the commission issued a notice of incomplete test claim informing the county that its decision to plead the entirety of Section 11171 was inconsistent with the argument that we make in the test claim narrative and where we ascribe cost to the test claim statute. So relying on the good faith of the commission, we thought that the best way to revise the test claim statute is just to narrow the focus to subdivision F to clean up the issues. And more than a year later, the revised proposed decision essentially says that we chose to plead the wrong test claim statute, which we find a little puzzling. And the reason why I'm mentioning this isn't just to, present a procedural gripe. It's because that notice of incomplete test claim doesn't actually appear on the public docket. So it's important for us to note this for the record, to acknowledge that there was a change in what the test claim pleaded from its initial filing to its revision. Last point, because I've held you here long enough. We informed the commission in our final comment to the proposed decision that the distinction between Medi-Cal and private medical insurance creates uncertainty about Medi-Cal regulations. And this is because Medi-Cal regulations include what folks call a discriminatory billing provision, which states that providers like the county cannot, quoting again here for the record, we cannot submit a claim for reimbursement for the rendering of healthcare services to a Medi-Cal beneficiary in any amount greater or higher than the usual fee charged by a provider to the general public for the same service, end quote. AB 1402 prohibits the county for charging the general public anything for child abuse exams. So the charge to private medical insurance is $0. If the charge to private medical insurance is $0 and the proposed decision approves reimbursement for exams rendered to Medi-Cal beneficiaries, the commission would inadvertently put counties in the position of charging private medical insurance nothing while seeking reimbursement for services rendered to Medi-Cal beneficiaries. We are concerned that this would seem to violate the discriminatory billing provision, which is to say that it's unclear that we could even seek reimbursement for any exams, period, with this poison pill in the proposed decision that distinguishes reimbursement on insurance status. The revised proposed decision does deal with this issue, but it says that the commission doesn't have jurisdiction to address Medi-Cal billing regulations, and quote, such discussion is irrelevant given that the test claim statute prohibits billing for exams. We are concerned about that finding because this is a problem created by the revised proposed decision, by the proposed decision itself. I want to be clear in this that no party has called for the distinction on the basis of insurance status. Certainly not the claimant, not the Department of Finance, no other county, and no other interested party. It's a distinction that appears for the first time in the proposed decision itself. So to conclude, the county believes that the proposed decision gets most everything right. We don't want to take that away from the proposed decision, but we do believe that it errs deeply as to the distinction between Medi-Cal and private medical insurance. That distinction, we believe, is unnecessary. It's inconsistent with the remainder of the proposed decision, and it creates legal uncertainties that threaten to jeopardize all reimbursement across the board. We respectfully request that the commission direct staff to amend the proposed decision so that it treats all child abuse exams the same. Thank you.
Thank you so much. Before I go to Department of Finance, let me bring it back to commission staff, or do you want to hold up until after finance?
I can comment at least briefly to give some perspective
Okay.
here.
Thank you. That would be
This is an unusual test claim. It's under Section 6C of Article 13B, and we're almost always under Section 6A. So there is no finding of a new activity necessary to be under 6C. And there is no new activity here. The exams are the same. They've been going on for over 20 years. We're under 6C because we can now use that to recognize a shift in costs, in financial responsibility from the state to the local governments. And the plain summary of this test claim would be that there has been a shift from where the state used to pay under Medi-Cal and the Victim Compensation Board, but there is no shift from private insurance to the counties that can be recognized under the state constitution because private insurance is not the state. So that's a summary of the key distinction of this entire claim. I could comment on other specifics right now if you like, or we could get back to that after finance.
Can I also just clarify the state of the law? You know, before Section 6C was even added by the voters in 2004, the only way the courts have found a reimbursable state mandated program is one, if the state is imposing new activities that constitute a new program or higher level of service. And as Laura said, there are no new activities here. Child abuse exams have been the same since 2002. The other way that they did allow for reimbursement, even before Prop 1A, was if the state had full administrative control of the program, meaning that they fully implemented the program and also fully paid for the program and shifted that whole thing over to local government. That was the case in Lucia Mar, dealing with special ed, certain class of special ed cases, and then also with County of San Diego dealing with the medically indigent adult cases. There was a case dealing with the Educational Revenue Augmentation Fund, County of Sonoma, where the counties were trying to raise the same shift argument, where in that case, the legislation reduced certain tax revenues of counties and shifted that portion of tax revenues to satisfy the state's Prop 98 requirement. There, the court found, well, that's not a shift because schools are paid for by both the state and school district local money. So the decisions of Lucia Mar and County of San Diego don't work. So at that point, that's when there was a negotiated agreement for a resolution that went before the voters to add Section 6C, which says there is now a new program or higher level of service for counties and cities only. Whenever the state shifts partial costs or to the counties. So you don't have to have new activities, but if the state, before the enactment of the test claim statute, had responsibility for a portion of those costs and they shifted it over to local government, then that portion would be eligible for reimbursement. So you can't, it's clear here there are no new activities. So, and it's clear that the state did not pay for private insurance before. So there's no way for us to get to that point. And we can't do equity. If there is an issue with Medi-Cal billing, that would have to be subject to legislation. It's not how Article 13B Section 6 works.
All right, thank you. Ms. Green Ross, you had a comment. Do you want to make your comment now, or shall I have Department of Finance do theirs first?
I just had a question.
Okay, go right ahead. Yes, please.
I guess I'm trying to wrap my head around everything you're saying, but getting back up to the actual statute that 1402 and the history and the reason for it. And it sounded to me like it was requiring what the claimant alleges, that they're not supposed to bill for anything because the state's going to pay. So first of all, I don't understand why the legislature, when they did that, didn't appropriate. Or we didn't even have to go through this for finance. Yeah, I like that answer, but I know it's not really relevant, but because here we are. But again, I'm just trying to, taking what you're saying, I still want to understand the plain language of the statute seems to have required them not to bill for whoever was paying.
So the services are exactly the same before and after. The only change was that they can't bill directly or indirectly the victim, meaning they can't bill insurance anymore because the state was supposed to pick up the tab. The state has not yet picked up the tab. So the County of Los Angeles case that the county was just mentioning, the 1987 case, you know, in that case, the court made it a big deal that we can no longer, with the enactment of Article 13B, Section 6 into the California Constitution, compared to prior revenue and taxation code statutes that addressed a mandate scheme, the old rev and tax code statutes did equate increased costs with reimbursement under those statutes. And the Supreme Court said, no, they're not the same. You cannot equate increased costs with what a new program or higher level of service is. So here we have no new activities. There's nothing new that they're doing. We agree they have increased costs, but increased costs alone, as the courts have repeatedly said, does not mean that you get reimbursement. You have to satisfy all the elements. Here, under the portion that used to be paid for by private insurance, there's no new activity and there's no shift of costs from the state because the state didn't pay that before.
But they're legally prohibited by the statute from billing private insurance?
Correct.
So it sounds like a legislative fix might be required.
That's exactly right. The solution that the claimant is seeking here is in the legislature's hands or in the citizens' hands to call their representatives and say, hey, this is upsetting. Please finish what you started. That's where we are, exactly.
Just Article 13B, Section 6 has to be applied as a question of law and not a question of equity. And so we can't fix it as a matter of equity.
Additional questions? Okay. Mr. Adams? Well, and I also still need to go to Department of Finance. So, oh, you want to hold? Okay, let's do that. And then we can bring it back to the commission for additional questions. Okay, Mr. Hill and Ms. Yap from Department of Finance, do you have any comments?
Finance has no comments on the staff recommendation. Thank you.
Okay, thank you so much. Okay, thank you. I just wanted to make sure we got through all of our witnesses first. Now let me go ahead and bring it back to the commission. Mr. Adams, go ahead.
Thank you. First, I want to say I'm absolutely embarrassed that we ever charged victims insurance. I find that just unbelievably outrageous that what victims go through and then their private insurance was hit. Unbelievable. As I sit here as a county rep, what's frustrating to me is that counties cannot escape these new cost shift. I understand that these are not cost shift from the state, but this legislation has closed a road for the counties to get reimbursement. And I agree that road should have never been open. They never should have been able. I'm also, once again, frustrated that I understand our sideboards. And as I've sat here for a number of years, I don't know how to get somebody's attention that these sideboards are awful. We're not the Commission on State Mandates. We're the Commission on sometimes state mandates. This is obviously something the state has put in. The counties cannot escape it. They're getting the cost. And then again, it takes a legislative fix. And I don't know at what point do I do a protest vote just to try and get somebody's attention that this is not right. This has to be changed.
Can I also just mention, because I think that the county maybe was misunderstanding our point in the revised proposed decision, there is a remedy here. And it's in Government Code Section 17551, which allows you to plead older statutes as long as you're first incurring costs within 1 year of filing your test claim. So this would have changed had the county pled the 2002 statute as a whole, because that's when 11171 was added. Then we would have, all of those activities would be new. The child abuse activities would be new. And we would be able to, propose a decision recommending reimbursement for all of it.
Is the response to the comment that they did plead it a certain way and it was suggested do it a different way?
No, they've never pled the 2002 statute. That's the point we're making here. If I don't know what went back and forth between the completeness review, that sounded like the whole section, the whole code section versus subdivisions on the 2023 or 2024 statute. I'm talking about pleading the 2002 statute. They could have done that. And that's the whole point when the legislature amended 17551 to allow you to do that. Whenever the legislature takes away money from you, you can, plead the old statute and, say that we just first incurred costs because of this 2023 statute. That was the whole point of that amendment. So there was a remedy, but there's nothing that we can do about it anymore because the last chance for a claimant to amend their claim was before the matter is set for hearing, and the matter is set for hearing when the draft goes out.
All right, thank you. Other comments from commissioners? Okay, and then yes, after Mr. Powell, we'll go to Ms. Gallegos. Go ahead, Mr. Powell.
So I see.
Pardon my interruption. I cannot hear Mr. Powell.
Sorry about that. In section G, there is a sentence bolded helpfully that says the costs associated with these medical evidentiary exams shall be funded by the state subject to appropriation by the legislature. And that's the full sentence. I don't see in that section a discussion about private insurance, v. Medicare or Medi-Cal or Victim Compensation Board. And so I'm just a little confused why that, the costs associated with these medical and evidentiary exams shall be funded is now under the proposed decision, not shall be funded entirely.
I'm going to let Laura just explain how this worked with the funding, and it was in forms from Cal OES that are not actually pled, but they're part of the program. But the legislature, G is still applicable. The legislature can still appropriate money, and there's nothing that we can do about that.
If they appropriate money, then the county then claim that money for private insurance exams, or if it's zero?
Under the decision, you're reimbursing the portion of when a child is eligible for Medi-Cal or victims compensation payment for that. If there's an appropriation from the legislature for all of the child abuse and neglect exams, then there's no reimbursement because unless they cut it short.
Was your question what would happen if the legislature does appropriate funding?
If tomorrow they appropriate, as much money as necessary.
Then all of the exams could be reimbursed through Cal OES as written.
So part of the issue is the failure to appropriate.
The failure to appropriate is the problem. So this claim came here, but being under Section 6C, we can only address what the state has shifted from itself to the counties.
And there's a lot of case law. We can't force the legislature to make an appropriation.
If only.
Hold on, Mr. Okay, let me go to Ms. Gallegos, please, first, and then Mr. Adams.
Yeah, just a quick question. Could you explain who is covered by the Victims Compensation Board and why all participants or people who've had exams would not be covered by one of the two, Medi-Cal or Victims Compensation Board?
My understanding of the Victim Compensation Board is that it's sort of a backup system for children who, for whatever reason, are not fully insured by Medi-Cal. But as far as the primary distinction here between the private insurance and anything the state covers is statutory. It is in the Welfare and Institutions Code that if the child has if anyone has private insurance, the state will not be paying for their medical expenses. So that line is just black and white.
All right.
Does that answer your question?
Okay. Mr. Adams.
Just to comment on the legislative appropriating money, they certainly have. And then there's also that little issue where in budgets, the administration will suspend mandate payments, which is another frustrating to county. I would hope if this goes to a court, that a judge would at some point say, these should have never been billed to private insurances. Never, never, never. This was always should have been a public cost, and therefore, darn it, state, you should be paying for all of them now.
Thank you. All right. Other comments? Ms. Nash.
I just want to say I share Mr. Adams' feelings and concerns and frustrations about the situation. I understand the state of the law and that our hands are tied, and I appreciate staff's careful explanation of the law, but this is one where I'm very frustrated.
Okay. Other comments or questions? Ms.
I
Green
third that
Ross.
motion. Thank you.
Okay.
The Honorable Chair, may I make another comment? I'm happy to wait.
Very, very briefly, please. Very briefly.
Okay. I just want to say that two principles here. One is that if this seems odd to the commission, it's because it is. At a very high level, what's happening in the test claim statute is that counties have a duty to do something. Previously, there was fee authority to do it. State takes away the fee authority. We still have to do this activity because it's a duty. We can no longer charge. It's a state mandate. In this case, if it seems like there is some sort of a loophole that the legislature can only fix, that is a correct reading of the problem here, and that problem is unconstitutional. The fix is by the commission, not by the legislature, because the legislature took away the fee authority of counties and accrued to itself the ability to pass on the cost to counties who have to subsidize these exams. What we're arguing here is that there is a new activity, there is a new program. That new activity, that new program is providing these exams free of charge. That was not something that counties had to do prior to the enactment of AB 1402. To the extent that the proposed decision tries to characterize the test claim as a Article 13B, Section 6C issue, we disagree strenuously. That is one basis upon which an activity can constitute an unfunded state mandate, but it is not the primary basis. The primary basis is a finding of a new program or higher level of service. That's the way that the County of Santa Clara pled the test claim statute. In the law, there's this principle that the plaintiff is the master of their complaint. We pled this as a new activity and a new program, not as a mere transfer of state responsibility. We think that's happening too, but the primary issue here is that there is a new program, there is a new activity, and it's one that does not distinguish on the basis of insurance status.
Thank you for being brief. I'll just, let me just comment. I'm not sure that I agree that this is a new activity. It's a new funding source that has to responsibility for paying for that activity, but the activity itself, in and of itself, I don't think is new. I will just note, again, I echo and understand the frustration of my fellow commissioners on this issue. Unfortunately, oftentimes we see the legislature pass bills upon appropriation. More times than not, we would like to not see that happen, but they do. Many times that is, there's some, again, I won't get into the politics and the tactics around that, but it happens frequently. As you can imagine, there then becomes a balance of if the state was to fund every legislation that came through upon appropriation, the state, it's untenable. They couldn't. the state doesn't have that funding source. So I hear your frustration. And I think that it is an activity, and the legislature does squarely have the responsibility during the fiscal budget process time to make the appropriation of this a priority. I think that, to your point, Mr. Adams, if they're going to pass a bill that they believe ties the hands of counties, and that they should fight for that as part of the budget process. But it's an unfortunate sort of impact that we're having before us as a result, I think, of legislative activity and the overall budgetary process that, again, the legislature owns a portion of, along with the administration. So, but I will just say, I don't personally believe this is a new activity. And unfortunately, I don't know, again, to Ms. Nash's comments, I think, our hands are a little bit tied. We have to make a rendering based on what is within our purview to do so. And unfortunately, I don't think this is something the commission can stand behind as an actual mandate because of new activity or otherwise. I do believe it is something that the legislature, along with the administration, has to work through to fund appropriately. So I'll end with that. I don't know. I want to go back to our attorneys if we have any additional last comments. Otherwise, I'm going to bring it back for a motion.
Madam Chair,
Okay. Yes.
sorry, I
Yes,
apologize.
I'll do public. Yes, just
Thank
one
you.
second, Dennis. Yes.
Oh, I want local government to really understand 17551 and how it was amended for your benefit to assist in these kinds of cases when a program is old and the state takes away money. You can plead that. And so just know that's available. And again, had that been done, we would have been able to recommend approval for the whole thing.
Thank you so much. I appreciate that. Okay, before I move it back to the commission to see if there's a motion, is there any public comments? And again, we're on item 4. Are there any other public comments on item 4? I see none in the room. Are there any online, Dennis?
No, there are no public comments online, Madam Chair.
All right, thank you so much. Okay, with that, is there a motion to approve staff recommendation or otherwise?
I'll make a motion to approve the staff recommendation for the proposed test claim decision in this case.
Okay, I have a motion by Ms. Nash. Is there a second? I will go ahead and second. If we could please have a roll call.
Mr. Adams,
No.
Ms. Gallegos,
Aye.
Ms. Green Ross,
I'm going to vote aye, but I'm going to amend. I just hope finance can help straighten this out with the legislature.
Ms. Jimenez,
Abstain.
Ms. Nash,
Aye.
Ms. Peralt,
Aye.
Mr. Powell.
Aye.
What's that vote? Because I'm sorry, it's a little over the place. Does that motion carry? Okay,
Yes, ma'am.
thank you. Okay, sorry, there was a little too, I just want to make sure. All right, that motion carries. Thank you so much.
We now ask the presenters participating remotely for item 4 to please turn off their video and mute the microphones. Those presenting in person, please return to your seat. Next is item 5. We now ask the presenters participating remotely for item 5 to please turn on their video and unmute their microphones. Chief Legal Counsel Camille Shelton will please present a revised proposed decision and parameters and guidelines on California Regional Water Quality Control Board, Los Angeles Region, order number R4-2012-0175, 13TC01 and 13TC02.
Good morning. The revised proposed parameters and guidelines address state mandated activities arising from the stormwater permit adopted by the Los Angeles Water Quality Control Board in 2012. The commission approved the test claim for reimbursement beginning December 28, 2012, and found that the test claim permit imposes a partial reimbursable state mandated program for the pro rata cost to develop and submit a watershed management plan or an enhanced watershed management plan for only the U.S. EPA adopted TMDLs. The proposed parameters and guidelines identify the reimbursable activities approved by the commission and the potential offsetting revenue identified in the test claim decision. Staff recommends that the commission adopt the revised proposed decision and parameters and guidelines and authorize staff to make any technical non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you so much. Would the parties and witnesses please state your name for the record?
Howard Guest of Burhan and Guest on behalf of the claimants.
All right. Thank you, Mr. Guest. Would you like to go ahead and begin with your comments?
Yes, thank you. Good morning, Madam Chair and members of the commission. First, I would like to thank commission staff and the commission for adding the city of Irwindale to the list of permittees mandated to comply with the San Gabriel River and impaired tributaries, metals, and selenium TMDL. I do not represent the city of Irwindale, but they are subject to that TMDL and should be included in the list. And I thank the commission staff and the commission for adding them to that list. Claimants do not agree with certain aspects of the parameters and guidelines. In particular, they do not agree with the finding that they have fee authority after January 1st, 2018 for the mandated activities. However, we recognize that this provision in the parameters and guidelines follows the test claims decision. Therefore, we will not argue it any further at this point, other than to state that we believe it's error for the same reason that the test claims decision on this point was error. Otherwise, I'm here to respond to any questions or to respond to any additional arguments. Thank you.
Thank you so much, Mr. Guest. Mr. Hill and Ms. Yap for the Department of Finance. Do you have any comments?
Finance has no comments on this matter. Thank you.
Okay, thank you so much. Are there any public comments on this item? I see none in the room.
Madam Chair, there are no online public comments.
Thank you so much. Let me bring it back to the commission members. Are there comments or questions from the commissioners? Okay, seeing none. Is there a motion to adopt staff recommendation?
Madam Chair, also move.
Moved by Mr. Adams. Is there a second?
Second.
Seconded by Ms. Nash. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez.
Aye.
Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Thank you. That motion carries. We'll move to item 6. No.
We now ask the presenters participating remotely for item 5 to please turn off their video and mute their microphones. Item 6. We now ask the presenters participating remotely for item 6 to please turn on their video and unmute their microphones. Senior Commission Counsel Laura Doherty will please present a proposed decision and parameters and guidelines on criminal procedure discrimination 24 TC 01. 02.
These parameters and guidelines address state-mandated activities arising from Penal Code Sections 745J3 and 1473F, as amended by the test claim statute, which requires county public defenders to represent indigent habeas corpus petitioners with criminal judgments entered before January 1st, 2021, who are alleging a violation of the Racial Justice Act. Neither the claimant nor the controller requested changes to the draft expedited parameters and guidelines or the draft proposed decision. The County of Santa Clara requested additional reimbursement for public defender work, and 6 counties requested additional reimbursement for district attorney work, including Contra Costa, Sonoma, San Francisco, Marin, Sacramento, and Stanislaus. However, Commission staff finds that these requests exceed the scope of the mandate and therefore recommend no changes to the proposed parameters and guidelines. Staff recommends that the Commission adopt the proposed decision and parameters and guidelines with the reimbursement period beginning July 1st, 2023, and authorize staff to make any technical non-substantive changes following the hearing. Thank you.
Thank you. Would the parties and witnesses please state your name for the record?
Sure. Fernando Lemus, County of Los Angeles claimant representative.
Tiffany Walston, Deputy County Counsel for the County of Los Angeles, and I am the claimant representative.
Thank you so much. Mr. Lemos and Ms. Walston for the claimant, would you like to begin?
Sure. We didn't have any additional comments, so we're just here to say that we didn't have any additional comments.
Okay, thank you so much. Ms. Hill or Mr. Hill and Ms. Yap from the Department of Finance, do you have any comments?
Finance has no comments on this matter. Thank you.
Thank you, Ms. Yap. Are there any public comments on this item? Seeing none in the room.
Madam Chair, there are no online public comments.
All right, bringing that back to commissioners. Are there any comments or questions, commissioners? Okay. Seeing none, is there a motion to approve staff recommendation?
I'll move to approve.
Moved by Mr. Powell. Is there a second? Second by Ms. Green Ross. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez.
Aye.
Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Thank you. That motion carries. We'll move to item 7.
We now ask the claimants representatives for item 7 to please, or item 6 to please turn off their videos and unmute their microphones. And those participating for item 7, please turn on your video and unmute your microphone. Commission Counsel Anna Barrett will please present a proposed decision and parameters and guidelines on internet websites and email addresses 24 TC04.
Good morning. These parameters and guidelines address state mandated activities arising from Government Code Section 50034 as added by the 2023 Test Claim Statute. The mandated program requires cities and counties to ensure their internet websites for use by the public and public email addresses for their employees utilize either a .gov first-level domain name or .ca.gov second-level domain name by January 1st, 2029, and to ensure that any internet websites with non-compliant domain names they continue to maintain after the deadline redirect users to a website with a compliant domain name. Standard definitions of the word website, as well as the rules of statutory construction, support that the legislation intended its requirements for internet websites for use by the public to extend to component files that make up a website, including web pages, web applications, or other related resources. No substantive comments were filed on the draft expedited parameters and guidelines, nor on the proposed decision and parameters and guidelines. The controller commented on the draft expedited parameters and guidelines to recommend no changes. Staff recommends that the Commission adopt the proposed decision and parameters and guidelines with reimbursement period beginning January 1st, 2024, and authorize staff to make any technical, non-substantive changes to the proposed decision following the hearing. Thank you.
Thank you so much. For parties and witnesses, if you could please state your names for the record.
Joshua Walden on behalf of the claimant, County of Santa Clara.
Thank you. Mr. Walden, for the claimant, would you like to begin?
Yes, thank you. The county is grateful to the commission staff for its expedited work on these parameters and guidelines, and would respectfully ask the commission to adopt the proposed decision and parameters and guidelines. I have no further comments prepared this morning, but would be glad to answer any questions.
Thank you so much, Mr. Walden. Mr. Hill and Ms. Yap from the Department of Finance, would you like to make any comments?
Finance has no comments on the recommendation. Thank you.
Thank you, Ms. Yap. Are there any public comments on item number 7? Seeing none in the room.
Madam Chair, there are no online public comments.
Thank you so much. Let me go ahead and bring this back to commissioners. Are there any comments or questions from commissioners on item 7? Okay, seeing none, is there a motion to adopt staff recommendation for item 7?
So moved.
Moved by Ms. Nash. Is there a second?
I'll second.
Seconded by Ms. Gallegos. If we could please have a roll call.
Mr. Adams.
Aye.
Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez.
Aye.
Mr. Nash. Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
Thank you so much. That motion carries. We'll now move on to item number 8.
Next, Program Office Technician David Chavez will please present item 8, the legislative update.
Good morning. The following are the legislative updates since the last time the Commission met. First, SB 414, School Accountability, Office of the Education, Inspector General, school financial and performance audits, charter school authorization, oversight, funding, operations, and networks, flex-based instruction, local educational agency contracting. SB 414 was introduced by Senator Ashby. Among other things to the Education Code regarding charter schools, this bill amends Government Code Section 17518 and adds charter school to the definition of local agency as follows. Local agency means any city, county, special district, authority, charter school, or other political subdivision of the state. There has been no new action on this bill. Next, AB 964, Commission on State Mandates, State Mandates. AB 964 was introduced by Assemblymember Hadwick. This bill amends Government Code Section 17558.5. This bill would require the controller to notify the claimant in writing within 30 days of an adjustment that results from an audit or review, and now requires the controller to allow a local agency or school district, at the sole discretion of the local agency or school district, to offset any reduced reimbursement as prescribed or to remit funds to the controller. On January 31st, 2026, this bill died pursuant to Article 4, Section 10C of the Constitution. And on February 2nd, 2026, this bill was filed with the Chief Clerk pursuant to Joint Rule 56. Next, AB 1452, State Mandates, Claims. AB 1452 was introduced by Assemblymember Ta. This bill amends Government Code Section 17564. This bill would change the minimum claim amount that requires the state to reimburse a local government from $1,000 to $800. On January 31st, 2026, this bill died pursuant to Article 4, Section 10C of the Constitution, and on February 2nd, 2026, this bill was filed with the Chief Clerk pursuant to Joint Rule 56. Finally, AB 395, Holidays. AB 395 was introduced by Assemblymember Gabriel. This bill amends Government Code Section 11131, the Bagley-Keene Open Meeting Act. Among other things, this bill would require that a state agency shall make every reasonable effort to avoid conducting any meeting, conference, or other function on a date for which the state agency knows or has reason to know that members of the public would be unable to participate or to be present due to the ritual observance of a religious, cultural, or ancestral holiday. There has been no new action on this bill. Staff will continue to monitor legislation for bills that impact the mandates process. Thank you.
Thank you.
Thank you, David. Next, Chief Legal Counsel Camille Shelton will please present item 9, Chief Legal Counsel report.
Good morning. There are no pending litigation cases currently, so I have nothing new to report. Thank you.
And thank you, Camille. All right, and that brings us to the Executive Director's report. I have 4 information items. That's someone's cue. Personnel. We're waiting for someone to turn on their camera. Oh, thank you. Jason Rogers. Last month, Jason celebrated 25 years with the Commission. He started as the one and only IT specialist. Over the years, he has seen the Commission through quite a few changes. He created multiple dynamic databases, including the Commission's Automated Tracking System, or CATS, which is used to track all Commission matters. He designed and maintained the Commission's website, set up electronic filing, and most recently converted the Commission's meetings to fully remote and then to the hybrid meetings we enjoy today. He currently serves as the Commission's Chief Information Officer. Congratulations, Jason.
Thank you for the kind recognition, Juliana. It's been an honor working for the Commission, serving the Commission, and I'm very, very, very grateful to be part of such a dedicated team. So thank you.
Thank you. Recruitment. The Commission's latest recruitment for the Attorney 3 position has been posted and is slated to close February 25th. The Commission's budget. The Governor introduced the proposed 2026-2027 budget on January 9, which includes an operating budget of $3.239 million and is broken down as $2.823 million for personal services and $416,000 for operating expenses and equipment. This is an increase of $28,000 from the total appropriation for the 2025-2026 budget after adjustments for salaries and benefits. The governor's budget also includes $91.21 million for local assistance or local agency mandated programs, a decrease of $2.893 million from the 2025-2026 budget. More detail is available in the Executive Director's Report. Workload. As of January 31st, there are 35 pending test claims, 31 of which are regarding NPDES permits. In addition, there are 4 parameters and guidelines, 6 statewide cost estimates, 4 incorrect reduction claims, and a proposed amendments to parameters and guidelines pending. Tentative agenda items. This is a reminder to please check the tentative agenda items on the Executive Director's Report for pending caseload documents on the Commission's website, which are updated at least bi-monthly to see when something is tentatively set for hearing. Draft proposed decisions on all test claims and IRC matters are issued for review and comment at least 8 weeks prior to a hearing date, and proposed decision approximately 2 weeks before a hearing. That's all I have, Madam Chair.
Thank you so much. Comments or questions from commissioners on Executive Director's Report, Legislative Report? Okay, seeing none. Okay. All right, with that, we are going to go ahead and move into closed session. The commission will meet in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission will also confer on personnel matters pursuant to Government Code Section 11126A1, and we will reconvene in open session in approximately 10 minutes. Thank you so much. Thank you so much. All right. Welcome back. It's 11:47. The commission met in closed executive session pursuant to Government Code Section 11126E to confer with and receive advice from legal counsel for consideration and action as necessary and appropriate upon the pending litigation listed on the published notice and agenda, and to confer with and receive advice from legal counsel regarding potential litigation. The commission also conferred on personnel matters pursuant to Government Code Section 11126A1. With no further business to discuss, I will go ahead and entertain a motion to adjourn.
Madam Chair, I would so move.
So moved by Mr. Adams, a second.
Second.
Seconded by Ms. Nash. I will go ahead and, roll call.
Mr. Adams. Ms. Gallegos.
Aye.
Ms. Green Ross.
Aye.
Ms. Jimenez. Aye. Ms. Nash.
Aye.
Ms. Peralt.
Aye.
Mr. Powell.
Aye.
All right. Thank you. That motion carries. We will go ahead now and adjourn the meeting at 11:48. Thank you, everybody. Have a great weekend.